Thank you for watching the following video by Steve Thompson of Thompson Legal PA regarding the filing of a proposal for settlement in your case.
Hi there, this is Steve Thompson from Thompson Legal, and I'm making this video to give you a little introduction to a procedural maneuver that I would like to file in your case that we do frequently that has various benefits that I'm going to discuss, and then we'll have a telephone call after you see this, but this is just kind of to warm you up and introduce you to the idea. So normally, when two parties are negotiating, whether it's pre-suit or whether it's in suit, either party can make an offer, can go back and forth, and then if it doesn't work out, each parties go their separate ways, and no harm, no foul. However, with a proposal for settlement, which I will refer to as a PFS, what we do is we offer to settle the case for a specific amount. And that offer remains open for 30 days. And the court can be aware of this offer, but not the actual amount, okay? So we file this proposal for settlement for a specific amount, and they have 30 days to accept it or reject it. If they don't accept it in 30 days, then it's automatically rejected. And what can happen? There's two ultimate benefits that the PFS can provide. First and foremost, they might settle the case. So if you file it at a number that they feel is fair or risky to them, then they may just accept it. And actually, it's important to note, and I probably should have led off with this, that if they don't accept the proposal for settlement and the case goes all the way through to a jury trial, which is rare, but it happens. We do jury trials frequently, but it is rare. But each case has to be prepared as if you're going to a jury trial. And so if you file this proposal for settlement, it goes all the way through to a jury trial, and then the jury awards you an amount 25% greater than your proposal for settlement amount, then they have to pay a penalty. And what is the penalty? The penalty is that they have to pay your attorney fees and costs from that point of when you filed the proposal for settlement through the end of the case. And that's going to be significant because it's measured on an hourly basis. And so what the PFS can do, why they have to really look at these and take them seriously, because it can take a lower value, medium value case and tack on $50, $75, maybe even $100,000, depending on how complex and how lengthy the case is. And so they'll take these seriously if they're done at the right amount. And so one benefit that it offers is that it can help resolve your case early on, because it could be too risky for them to continue on with the process. And it's worth noting that we can't file this until 90 days after the defendant is served. So you can't just file a lawsuit and file it the next day. We have to wait, like I said, 90 days. Now, what's the other benefit? Well, if you file it for a fair number and they don't accept it, down the road, after they take some depositions, after they do discovery, maybe after mediation, they may realize that they made a mistake and they should have accepted it. And now they're looking at a case where perhaps they should have settled for, just making a number up, $25,000. And now they say, oh man, there's a real risk that they may beat that $25,000 number. And now that $25,000 is going to turn into $100,000 by virtue of the penalty of adding the attorney's fees. And so the tricky part with the proposal for settlement is to find the right number. And what I like to tell clients is, for a client who would prefer to get the litigation done sooner rather than later, they might leave a little bit of money on the table, but maybe they don't want to wait 6 months or 8 more months or a year to get to a jury trial. I would go on the low range, and if accepted, it's a number that you can live with. You're done, the case will be wrapped up in the near future, and you don't have to go through the continued litigation process. For clients that say, I don't care about litigating, I'm happy to do it, I've already come so far, then I can tell them to go on the higher range of what I recommend. Now, what's the benefit of the lower range? The benefit of the lower range is higher likelihood of it getting resolved. And if they don't accept it, it creates more leverage for you down the road because they may realize that they made a mistake and be uncomfortable with that number sitting out there. Now, what's the benefit for the higher number? Well, the benefit, and what's the downside for the lower number? The downside for the lower number is you might leave a little bit of money on the table because maybe they would have paid more long term. Now let's talk about the higher number. So let's say that my recommended range is 25 to 35,000. And so if I have a client that says, I would like to, I don't mind litigating and I want to get maximum value, then I recommend for them to do the filing at the higher range of 35,000. And for that client, they are going to get maximum value if it's accepted, but it's a lower likelihood that the defense actually does accept it. And if they don't accept it, we don't have the same leverage as if we had a proposal for settlement that expired at 25,000. And so we've seen this benefit our clients in all kinds of ways. 1, earlier resolutions on cases. 2, defenses realizing that they made a mistake and then paying in excess of the proposal for settlement. Off the top of my head, we've had a $10,000 proposal for settlement and they paid $70,000 later on. We've had just recently $115,000 settlement and they paid $150,000 on it. I think we've done this a number of times. Furthermore, the other benefit and what we've seen is you go through to a jury trial and what we call popping the PFS, and that's getting that 25% above what the PFS was. We did this with an individual who was a pedestrian struck by a vehicle and fractured her foot. And we filed a $40,000 proposal for settlement. And they realized they made a mistake. They ended up offering about 50, and the client didn't accept it, pursuant to our recommendation. And the jury awarded 60. And so $60,000 is more than 25% greater than $40,000. And so they had to pay the penalty of the attorney's fees. And so it ended up being, they paid a total of around $130,000. And so how did that benefit the client? Benefited the client because she saved on the contingency fee where she didn't have to pay the attorney's fees out of that $60,000. So it saved her $24,000. And for the law firm, obviously we were really excited because that case now is measured on an hourly basis and the attorney's fees were really high and they had to pay those attorney's fees separate. So the attorneys made more money and the client made more money as well. More recently, same thing, we got a jury verdict. We filed a proposal for settlement for $35,000 on a trip and fall against the city of Miami, and the jury came back and awarded $70,000. So that one's pending with the calculations of the attorney fee. However, the client will save 40% of $70,000, which is $28,000. So that's the long-term benefit if it goes all the way through to a jury trial, which is obviously not common, but does happen. And so I want to talk to you further about it, but I wanted to, like I said, send this to you as an introduction. So you're thinking about it. I'll give you the recommended range. I'll tell you, well, if we file a proposal for settlement for X amount of dollars, this is likely, what you'll walk away with. And then you'll make a decision as to where a good number is for you. So I appreciate you listening to this video and getting ready, and we will talk in the near future. Bye-bye.
Feel free to reach out with any further questions. Thank you and have a great day.